14 AOS 1971 Section 2-104, 14A-104, that even though contract executed in Texas, provisions of Section 2407, supra, were applicable and security interest in Corvette was void, that bank was assignee of Plains rights, and bank did not have valid security interest in Corvette. Section 2407, supra, applies only to consumer credit sales as defined in Section 2104, supra. There is no similar prohibition applicable to consumer loans as defined in 14 AOS 1971 Section 3104, 14A-104. Bank first contends trial court erred in finding transaction between bank and appellee was consumer credit sale rather than consumer loan. 14 AOS 1971 Section 2104, 14A-104, 1, provides that, except as provided in subsection 2, consumer credit sale is sale of goods, services, or interest in land in which credit is granted by person who regularly engages as seller in credit transactions of same kind, be buyer's person other than organization, c. the goods, services, or interest in land are purchased primarily for personal, household, or agricultural purpose, d. either debt is payable in installments or credit service charge is made, and e. with respect to sale of goods or services, amount financed does not exceed $25,000. Section 2104, 2a provides unless sale is made subject to act by agreement. Consumer credit sale does not include sale in which seller allows buyer to purchase goods or services pursuant to lender credit card or similar arrangement. Bank admits transaction between appellee and Plains constituted consumer credit sale. An installment sales contract was assigned to it. It argues after appellee selected car, Plains and appellee contacted bank requesting loan, that sale of Vega was complete at that time and application for loan was second transaction. It contends it rejected application and only accepted it after additional security was offered, and contends this arrangement constituted loan between it and appellee. If appellee had borrowed money from bank to purchase automobile, and then used proceeds of loan to purchase automobile in cash transaction, the transaction between bank and appellee would probably be held to be a loan. See People's Finance and Thrift Company of Ogden v. Perry, 30 Utah, 2D 282, 516 p. 2D 1400. However, in present case appellee dealt only with Plains. He entered installment sales contract referring to him as purchaser and Plains as seller. He did not execute a note or any instrument of indebtedness with bank. Bank took assignment of Plains rights under contract. After appellee defaulted, bank repossessed automobiles, returned them to Plains, and Plains repurchased sales contract from bank by paying bank amount of unpaid balance. We conclude only inference which can be drawn from these facts is that there was no consumer loan transaction between appellee and bank. The transaction between Plains and appellee was consumer credit sale, and bank was merely assignee of Plains rights under sales contract. Bank next contends court erred in ruling it was improper to take additional security in a consumer transaction. Under this contention, bank first argues transaction between it and appellee was consumer loan. Since we have previously determined there was no loan by bank to appellee, we need not consider this contention. Bank further contends trial court erred in refusing to take judicial notice of Texas statutes relating to this transaction. This argument implies security interest was valid under Texas law. 14 AOS 1971 Section 1201, 14A-1201, 5, provides in part. 5. If a consumer credit sale is made in another state to a person who is a resident of this state when the sale is made, the following provisions apply as though the transaction occurred in this state. Be a seller or assignee of his rights, may not enforce rights against the buyer with respect to the provisions of agreements which violate the provisions on limitations on agreements and practices. Part 4. Appellee was resident of this state at time sale was made. Seller's assignee brought replevin action to enforce its security interest in this state. The provision of security agreement granting seller security interest in Corvette violated Section 2407, supra, one of the provisions on limitations on agreements contained in Part 4 of Oklahoma Consumer Code. Section 1.201, of Uniform Consumer Credit Code is identical to Section 1-201, supra. Comment 1 thereto states, this section allows the enacting state to apply all of these protective provisions to its own consumer residents when enforcement actions are brought